Hi, and welcome to the Law Simplified's Public Law Workshop. I'm Shavin Bandaranaike. First and foremost, I'd like to thank everyone who registered and who's live here today as well. This is the very first public law workshop that I'm conducting. Last week we had criminal law. Next week we'll be having contract and several other subjects in the upcoming weeks as well. So I do appreciate that you're coming along on this pretty experimental journey with me with the workshops. It's a different format that I'm trying to do sessions with, but let's see how things go. I do see some of my past masterclass students as well, Jing and Lucy. Thanks a lot for joining me today. And just to outline a few things, since this format is not one-on-one in the sense of a usual session, make sure that you use the comment box as well as the ask a question button at the bottom to leave any queries that you might have. Most likely, once we go through each individual topic, you might have questions that you have in relation to each one. But at any point of time, do make sure that you put the queries out there, and I'll get to it when I get to it. Right. So having said that, fundamentally, how this workshop is going to be structured is we're going to spend some time going through the theory elements of each individual major or fundamental topic of the subject itself, and then we'll have a little bit of an outline as to how you're examined and what to expect from an examination, or for that matter even an assignment submission if you're coming in from a different jurisdiction or an examination or a university structure. Right. Now, having said that, the very first topic that we're going to look at and that we're going to outline is the fundamental topic, I would suggest, when it comes to public law, in terms of the UK at least, which is the Constitution. So let me just get that up on screen real quickly. Okay. Now, the reason why this particular topic is fundamentally important to the UK is because the UK has what we call an unwritten constitution, or rather many jurists and academics consider it as an unwritten constitution. Now, as you might know, when someone suggests something as unwritten, there is a counterpart to that, and that is a written constitution, which most countries around the world have. 99.9% of the countries around the world have what are called written constitutions. But a fundamental way, something that's important for us to recognize and appreciate, is that considering the UK's constitution as written or unwritten in that case is actually a fallacy. It's quite wrong. The reason why I'm saying that is because the UK doesn't have a constitution which is found in one place. In other words, we like to consider it as being fragmented. Whereas a normal written constitution, which you would find in many other countries around the world, you have one succinct or one fundamental document that has all of the rules and regulations that are there in terms of running a country. The UK doesn't have it in one place. It is sourced from multiple locations. So, for example, if I'm to pinpoint on our spider graph, which is going to be our guide for this topic, you'll notice under sources, we have considered two primary indicators, one being legal and the other being non-legal. So what this really alludes to is the fact that when you look at the United Kingdom, the constitution in itself is derived from multiple legal and non-legal sources. Legal sources are things like acts of parliament, pieces of legislature that parliament enacts. You have precedent case law, judgments or decisions by the courts of law, by the appellate courts, both the Court of Appeal and the House of Lords at that time and the Supreme Court today. You also have formally regulations of the European Union, which is now in doubt as Brexit has already happened. You have provisions within the European Convention of Human Rights and decisions of the European Court of Human Rights. You have prerogative powers, which are very similar to executive authority in countries where there are executive presidencies. But in the UK, you have the Crown or the Queen, and you have decisions made within Parliament and powers of the members of Parliament, which are called privilege. Now, all of this combined amounts to what we call legal sources of the Constitution. The very crux of it, the basic outline of that, is that if you break any one of these, it amounts to breaking the law. So you have gone against the law, which means you can be punished. On the other hand, many have suggested that the UK functions in the way that it does because of what we have referred here to as non-legal sources, specifically that of conventions. Now, what this means in terms of conventions, you can simply think of it as traditions of the UK. Now, this is a good point in which for me to outline and illustrate what's unique and very specific about the UK, something that many students don't often look at or consider. Essentially, if you take any country that has a written constitution, one in which is in one singular document in a singular place, the reason why they have a written constitution is because they have gone through some sort of historical turmoil or upheaval. So, for example, this is an example that I always take and I usually cite. In Sri Lanka, we were a colony, a former colony of the British. So when they left us, we had a requirement that we needed our own laws, a way to govern ourselves, to elect those who govern us, punishments, how exactly the country is going to be formed and divided among the different provinces, and so on. So we had the requirement of creating a written constitution. Pretty much every country in the world out there, be it in the African continent, the United States and Canada, North America, Australia, the subcontinent that is India, Pakistan, and Sri Lanka, most countries in the world have a written constitution primarily because there has been a break in their history. The UK, after 1066, post-Norman conquest, there has not been a reason for such a thing, and they've always done things based on tradition. So that is where this convention or the non-legal sources comes in is why it's important as such. And many have said that it's because of this tradition that the UK functions in the way that it does. One of the reasons why is because the laws sometimes suggest that people can take arbitrary decisions. For example, the appointment of the Queen is the prerogative power of the appointment of the Prime Minister, is the prerogative power or the sole power within the Queen. She can appoint, the Crown rather, can appoint anyone that she wants to that position. For all intents and purposes, any individual can become Prime Minister if she chooses that person. But the convention or the tradition is that the leader of the party that secured the most number of votes in the general election will be invited to be the Prime Minister and form his own government. So you notice that it's the tradition that makes this fundamentally possible. Now, this subject and this topic at large, you'll notice that the way I'm doing it is quite connected to other areas as well. Already, you would have heard me use words like parliament. You've heard me use the words like royal prerogative, privilege, common law, ECHR. And that's the reason why we start with this topic. This topic essentially provides us with a handle to understand every other topic. And having said that, we will go on to the next element within this topic as well, which is how do we look at and consider the characteristics of a constitution? Because a constitution, much like the country itself, is a living, breathing thing. It keeps moving, it keeps changing, especially in the UK, a culture and a country that is ever growing and is constantly on the move. Now, this is in relation to the divisions and how we consider to define constitutions as such. Now, just like we define people, which we shouldn't, but just like we define and allocate certain characteristics and traits of people. For example, I am Sri Lankan. I'm a male and I'm Sri Lankan. These are two characteristics that define who I am. It's not everything, but it's certain characteristics. Similarly, you would be defined by virtue of your personality and characteristics. So too would a constitution. Because remember, a constitution is essentially a manifestation or the representation of what the country is. So if you are to look at any constitution, it should be a mirror image. In other words, a reflection of how the country operates and what it in fact is. So you'll notice here a few words that I've used to suggest certain adjectives that you can use or certain traits that you can use to define a constitution. So, for example, a monarchical constitution is one in which the head of that particular country or the state is a monarch, is a king or a queen. Unwritten refers to fragmented, as I'd like to refer to it, but where the sources of the constitution are not in one place, but is supposed to be derived from multiple places. Unitary means that the powers are vested within a singular unit, where powers are generated and disseminated from one place. Flexible essentially means that it's a constitution that is changeable. You can change and make amendments quite easily. Fused is the opposite of that. It's a constitution that once set is very difficult to change. Now notice how these characteristics will have its counterparts as well, apart from monarchical, of course. Unwritten would be considered as written as a counterpart. Unitary would be considered as a federal constitution as a counterpart. Flexible is fused. Now, when we look at different constitutions, you will then have different characteristics culminating in what we see as the constitution of that day. So the UK, for instance, could be considered as a monarchical, unwritten, unitary and flexible constitution in terms of its characteristics. But there have been many criticisms that have come about, and we'll touch on some of them as we go along our workshop and through our other topics as well. Now, having said all of this, you would notice that we have looked at two fundamental areas in terms of this topic. On the one hand, the anatomy of the Constitution. How exactly is the Constitution built in the UK? What are its constituent components? How exactly has it affected the functioning of it? On the other hand, we have looked at what traits or characteristics have defined the Constitution. Now, this is a good point at which to sort of essentially tell all of you what is most important in tackling questions, tackling problems that might be associated primarily with the questions that are posed to you in terms of constitution and public law at large. When it comes to this particular topic, the topic of constitution, the most important thing to understand is that you cannot answer these questions in isolation. This is true about every other topic as well in public law, but more so in terms of constitution. Constitution by itself cannot be answered on its own. It has to have elements of parliamentary sovereignty, separation of powers, a bit of rule of law here and there, and Human Rights Act. Because these elements are what essentially changes the nature and the scope of the Constitution of the UK. Now, to aid in the way that you answer these questions, you would notice in this spider graph as well, several opinions and arguments have been presented by virtue of different jurists and academics. From, for example, Ivor Jennings, suggesting that an unwritten constitution is one which has been added to constantly, to Griffith suggesting that it is political, and Brezier further essentially demystifying what Griffith said by suggesting why it is political. It's because the UK's constitution is so flexible that any politician that promises a certain thing during his campaign can't resile from affecting it. He can't stay away from it. He has to go ahead. One thing that I'm most personally that I'm most fascinated by is Jennings' view about conventions or non-legal sources, where he says that conventions are the flesh that clothes the bones of law. And what he has eloquently put there is what we suggested earlier. Essentially, the fact that the reason why the UK functions the way that it does is because it's tradition that drives the law. It's purely because of that. That's the convention is what gives the Constitution its shape. Right. Now, by and large, apart from this, the most important element to understand, apart from the anatomy as well as the characteristics that define the very nature and personality of the Constitution, is what has happened over the number of years that have put into doubt these characteristics and the reforms that have been brought about. There are fundamentally 4 reforms that are important for us to recognize and understand, some of which are connected to other topics as well, namely the Constitutional Reform Act, which took away the powers of certain individuals, as well as established and recommended the establishment of important institutions within the UK. The Human Rights Act of 1998, brought about by Tony Blair's Labour government in 1997, which codified internally that which the UK had been a signatory of for quite some time, namely the ECHR. The devolving acts in terms of the Scotland Act, the Government of Wales Act, and the Northern Ireland Act, which put into question whether the UK was in fact any more unitary, or at least purely unitary, or whether there's a little bit of devolution that has taken place, and the different situations in which prerogatives have been questioned, or problems in relation to prerogatives have been brought about, and those being codified by virtue of acts of parliament. Now, by and large, in terms of constitution, these are the fundamental components that you need to be aware of and you need to keep in mind and keep in check before proceeding into looking at questions in the first place. And when you do attempt questions in constitution, always remember that, again, don't take this topic in isolation. It is not like other subjects. You have to show an examiner that you're familiar and well-rounded in terms of the overall subject matter. And when you're answering questions, always bring in other aspects as well. Okay, so that was Constitution. Before we proceed on to the next topic, as we add on and move on in our workshop, if there are any questions, please do put it down on the comment section or the ask a section button. You can click and ask me a question. Let's give it about a minute or two. If you have any questions, please do let me know before we proceed.